Heyo, folks! All right. A return to the Sandra Birchmore case. Sandra Birchmore this case is related to the Karen Reed case, but still, it's different cases. It is extremely bad in different ways. But if I had to choose, the Sandra Birchmore case is both better and worse. Worse because of what happened to Sandra Birchmore for years. No, and the precinct knew it, that several of the police officers in Stoughton used her as a toy. And then one of them, Matthew Farwell, who is now charged with her ending, and they all covered up for him. So that is what makes it worse. What makes it better is that Matthew Farwell is charged in federal court, not in state court, because the same people, D.A. Morrissey and his gang of merry assistant district attorneys, don't want to. They are perfectly happy with continue to protect the groomer and rapist Matthew Farwell, just as they protect the officers and the actual suspects in the John O'Keefe murder. But we are here for the Sandra Birchmore case. We are going to go through one of the latest filings. It is Matthew Farwell's attorney's motion in limine to exclude expert testimony of Dr. Michael Baden. Or Baden, I don't know how he pronounces it. He is the world-renowned medical examiner who broke through the Norfolk County corruption, who found the evidence. So in one way, it's perfectly understandable that he wants this expert thrown out. At the other hand, yeah. But we'll go through it with legal analysis and a whole lot of snark. Welcome to the show.
Santa Claus, riding in with the winter laws. Santa Claus, streaming live for the roaring masses. Ho, 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 raise them horns, old Judge King in a crown of thorns. Santa Claus, streaming live for the roaring masses. Santa Claus, Santa Claus, Santa Claus, Santa Claus. Santa Claus, right?
All right. Let's see here. There. No. There. Okay. Should be bigger. Okay, I have to remove that one. There. All right, folks. This will be interesting. Okay. United States District Court, District of Massachusetts, United States of America versus Matthew Farwell. Hearing requested. Defendant's Rule 702 motion in limine to exclude the expert testimony of Dr. Michael Baden. Matthew Farwell, the accused, pursuant to Federal Rule of Evidence 702 and 403, respectfully moves this court to exclude in its entirety the proposed testimony of Dr. Michael Baden, or in the alternative, to substantially narrow the scope of his proposed testimony. Footnote 1. For efficiency purposes, Mr. Farwell intends for this Rule 702 motion to also serve as a motion in limine. Should this court decide not to exclude Dr. Baden's testimony in its entirety, Mr. Farwell respectfully asks the court to determine the admissibility of each statement or conclusion for trial, and in so doing to substantially narrow both the scope and the statements of that testimony for trial. In other words, they want a Daubert hearing. They want a Daubert hearing. A Daubert hearing is when the court allows either side, if it's a defense expert or a prosecution's witness, to examine that witness. Is he really an expert? Is he an expert in that specific field? Is his conclusions within the scope of reliable medical science or science, depending on which kind of expert it is? If you saw if you watch the Can Read trials, you know what a Daubert hearing is. And because Judge Bev allowed everyone to be subject to a Daubert hearing when it came to Can Read's experts, including but not limited some of the country's leading experts in that field. Meanwhile, the state's experts, one of them, a dog trainer or dog whisperer, would have been allowed to testify according to Judge Bev without the Daubert hearing. Yeah. It's infuriating, isn't it? All right. As outlined herein, Dr. Baden's reliance on incorrect and insufficient facts and his unreliable applications of accepted methodologies failed to meet the standards delineated in Rule 702 and the Daubert line of cases. Daubert et al. Yeah. They quote these cases. 1992, 1997, 1999. Just for the shits and giggle of it. Let's check with AI here. Dr. Michael Baden is a renowned American physician and board-certified forensic pathologist. Former chief medical examiner of New York City, and as the chief forensic pathologist for the New York State Police. Acted as chairman of the forensic pathology panel for the House Select Committee. Yada, yada, yada. He was involved in the OJ trial, the von Bülow trial, the Phil Spector trial, independent autopsies for George Floyd, Michael Brown, and Eric Garner. Yeah, and on and on and on and on. So, yeah, it's a bit of a good luck. It's a, yeah. Yeah. And, of course, Trooper Paul for the state side in the Karen Reed trial. Yeah, Trooper Paul, who used science and stuff. Additionally, the probative value of Dr. Baden's testimony is, quote, substantially outweighed by the risk of unfair prejudice it creates. Judge, this is devastating to my case. Throw him out. Yeah, no. Is it prejudicial? Yeah. Is it unfair? No. let's see here. And that should be excluded under 403. Mr. Farwell requested a Rule 702 Daubert hearing to appraise the veracity of the facts on which Dr. Baden bases his opinions, as well as, quote, examine his conclusion to determine whether they flow rationally from the methodology employed. This feels like a quote from somewhere. Yeah, I don't find an actual quote, but it seems like this is, folks. For you who don't know, hi, I'm Nick. Santa Claus. Besides doing labor and employment law for close to 35 years, I spent 3 years in the European Parliament as a documents analyst, which taught me how to not only to read and interpret documents, read and interpret wordings, but spot differences. This line here is so out of touch from the rest of the language. So that is what made me react a bit. And I don't know why. It's just it stands out to me. Either way, summary of argument: whether Miss Birchmore's death was a self-ending, as the Massachusetts Office of the Chief Medical Examiner initially pronounced, an accidental death at her own hand, or a homicide, as the federal prosecution alleges, is the central issue in this case. It is. It is the central issue in this case. It is the truth versus corruption. Therefore, any expert opinions as to whether a killing occurred is relevant, but they require significant vetting to ensure that the proffered experts will aid the trier of fact and are basing their opinions on reliable foundation. Yeah. Yeah. But I think they gave it away here when they say it. You have here the Massachusetts Office of the Chief Medical Examiner initially pronounced, yeah, and then changed his mind again. I don't know. But I think the ME there has now come to undetermined or something of the sort. Which here is, since this is the central issue in this case, yeah, then you have a battle of the experts, not a motion. I can tell you already at the first few lines of the summary of argument here that the ruling should be, well, call your own expert, let the jury decide. Or you have an issue with it, you get to cross-examine. The government bears the burden of establishing the reliability of Dr. Baden's testimony. Yeah. Review of the government's expert's disclosure and Dr. Baden's 4-page letter encompassing his conclusions as to the cause and manner of Sandra Birchmore's death do not meet that burden. Oh, really? Because Dr. Baden's conclusions are ungrounded from current scientific literature, based on wrong and or insufficient facts, and contain, quote, too great an analytical gap between the data and the opinion proffered. And they quote Joyner here. Yeah, they better. I mean, ungrounded from current scientific literature. That is a very, very strong statement that demands undeniable evidence to back it up. Let's see when we read through this if we find it. These deficiencies also make Dr. Baden's testimony substantially more prejudicial than probative and create an undue tendency to confuse and mislead the jury. Therefore, Dr. Baden's opinions should be excluded under 702 and 403. Again, LMP says, again, they can't be serious. This feels like a bad joke. This is defense attorneys zealously advocating for their client. I don't mind. I don't mind this. I actually don't, because in order for us to be very safe when the jury comes back with a guilty verdict, to be safe from every type of appeal, the defense has to produce the absolute strongest arguments against guilt at every moment, against every evidence, every moment. They have to. Now, I believe they have jack shit to work with. But if Farwell had a hack who just phoned it in, no, I want Farwell to have the best possible defense, because that would make a conviction undeniable, even for the corrupt assholes in Norfolk County. So I actually don't mind seeing these filings. I think it's this far it's not good, but they have to do it. The only thing that would be worse than this would be to not challenge him at all, Dr. Baden. To not challenge Dr. Baden at all. Factual background. The court is familiar with the facts of this case, so only those facts relevant to this Rule 702 motion will be outlined here. Additionally, Mr. Farwell incorporates her in section 1A of the factual background, footnote 2. These sections outline the forensic evidence timeline from February 4th, 2021, when Ms. Birchmore's body was found, through the autopsy and recent DNA testing, as well as the timeline of the federal investigation beginning in approximately 2023. Yeah, isn't it strange that the feds got involved in both Sandra Birchmore and Carrie Reed case roughly the same time? Can it be because the overlap of the people investigating this, and they saw corruption on day? Factual background is blah blah blah. Exclude expected. Let's see here. Additionally, a corpse is here in section 1A in the factual background in Rule 702 motion in limine to exclude the expert testimony of Dr. William Smock. Hereinafter Smock's 702 motion to be filed on August 3rd to streamline this court's review of the two 702 motions. Okay. So they want to two state experts they want excluded. The timeline of Dr. Baden's involvement in this case. The civil lawsuit brought by Ms. Birchmore's family. Sometime in 2021 and 2022, Darlene Smith, the surviving aunt of Sandra Birchmore, hired lawyer Stephen Marullo to bring a civil lawsuit against Matthew Farwell, William Farwell, Robert Devine, the town of Stoughton, and the Stoughton Police Department. The initial complaint was filed December 29th, 2022. See Darlene Smith as a personal representative of the state of Sandra Birchmore v. Farwell, blah, blah, blah. As relevant to this motion, the civil suit includes a wrongful death claim regarding Ms. Birchmore's death. On January 3rd, 2024, the law offices of Stephen J. Marullo wrote to the Massachusetts Office of the Chief Medical Examiner, requesting information as to the fracture of the hyoid bone found during the autopsy of Ms. Birchmore. Specifically, Mr. Marullo's office asked, is a broken Hyoiboin. For fuck's sake. Sorry, folks. Broken throat bone. Consisted with cases of asphyxia, where a person is simply leaning into a ligature as opposed to a violent drop or strangulation. Additionally, the office inquired as to, quote, testing protocol in relation to deaths involving a fetus such as this, and was any additional testing undertaken. The OCME replied approximately 2 weeks later, explaining, you question whether this fracture is consistent with cases of asphyxia, where a person is simply leaning into the ligature as opposed to a violent drop or strangulation. After consulting with the medical examiner, she indicated that that bone can be fractured without strangulation or a violent drop. Yeah. As in leaning over, not that leaning in and slowly asphyxiating a person. Yeah. So, they confirmed it. How about that? As to the testing of the fetus, the OCME stated the medical examiner conducted an external examination of the fetus and made the determination that no additional testing or examination was needed in relation to the cause and manner of death for Ms. Birchmore. 2. The findings of Dr. Baden outlined in his June 18, 2024 letter to the law offices of Stephen J. Marullo. Dr. Baden was retained by Marullo in or around early 2024, apparently to opine as to the cause and manner of Ms. Birchmore's death in relation to the aforementioned civil lawsuit. Footnote 3. Defense counsel has received no documentation as to what information attorneys of Marullo, Smith, or any other family members of Ms. Birchmore has shared with Dr. Baden, if any. Have you asked? Don't know. As discussed post in this June 18th, 2024 letter, the Baden report to Ms. Smith's attorneys, Baden concluded that the autopsy findings are typical for homicidal manual and ligature strangulation and are atypical for hanging. That the neck ligature was tied to a doorknob to give the appearance of a suicidal hanging, that the cause of Miss Birchmore's death is strangulation and the manner of death is homicide. 3. The federal government's notice of Dr. Baden in the instant case. In 2026, the government disclosed to Mr. Farwell, pursuant to Federal Rules of Criminal Procedure Rule 16, that it would call Dr. Baden to serve as an expert in the instant case and attach the Baden report as it was issued to Marullo in June 2024. The government notes in its expert disclosure that Dr. Baden has not received any additional materials since he authored his June 18, 2024 report. Absent from discovery is any evidence that the government has directly consulted Dr. Baden regarding the instant case. It bears noting, too, that the government's disclosure differs from the Baden report as it changes Dr. Baden's cause of death determination from strangulation to asphyxia strangulation without explanation for the change. But you had it up here. Here. Your question. Let's see here. Yeah, here. Mr. Marullo's office asked, blah, 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 with cases of asphyxia. So it is there. Yeah. Did they change? I would say that this is a clarification. I would say, yeah. I would say that is a clarification. Asphyxia, strangulation. But, yeah. All they have to do is explain it. Rules of, okay, legal standard, federal rules of evidence. Rule 702 of the Federal Rules of Evidence governs the admissibility of expert testimony and codifies the trial court's gatekeeping role regarding expert testimony. And then it's just gatekeeping, evaluate data, yada, yada, yada. Federal Rules 403. Argument. Okay. Let's see what their actual arguments are. The court should exclude Dr. Baden's opinions because they are unreliable. Dr. Baden's opinion as to the cause and manner of Miss Birchmore's death and the determinations underpinning that opinion should be excluded because they do not accurately reflect what is presented in the sources he cites, are not grounded in the current scientific literature in forensic pathology and anthropology, or sufficient and or correct facts, and they contain significant analytical gaps. Okay. Interesting. Dr. Baden's physical findings are not the produce of reliable principles and do reflect a reliable application and don't, I assume they should have written here, don't reflect a reliable application of forensic pathology principles to the facts of this case. In his review of the physical findings at autopsy, Dr. Baden observed prominent hemorrhages in the eyes and skin above the ligature, an abrasion of the chin, hemorrhage in neck muscle, and fracture of the right hyoid bone. Then, citing to two textbooks and his experience, Dr. Baden cites to Vincent De Mayo and Dominic De Mayo, Forensic Pathology, pages 247 to 269, and Spitz and Fisher's Medical Legal Investigation of Death, Guidelines for the Application of Pathology. Okay. Dr. Baden opined all of these pathologic findings are commonly found in homicidal strangulation, manual and ligature, but not in self-ending hanging. The physical findings. In his description of the physical findings at autopsy, Dr. Baden failed to explain that blah 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 hemorrhages in the eyes and skin above the ligature, an abrasion on the chin, hemorrhage in neck muscle and fracture in the right hyoid bone, Baden report at 2 are also common in incomplete self-ending hangings. Oh, you idiot. Mr. Attorney, do you know what incomplete self-ending hangings are? It is struggle. Changed their mind. The body reacts, want to live. That's an incomplete. The staging from the alleged staging from Mr. Farwell and the first initial determination from the state's medical examiner was self-ending, successful self-ending. Do you know the difference between incomplete and successful, if you can use that word, is died, didn't die. The difference is remarkable. Nor is there evidence that he even considered this alternative, despite the very textbooks he cites clearly do so. Yeah, idiot. No, oh. Again, defense, they have to grasp at straws. This is a... No, okay. As a threshold issue, Dr. Baden did not mention in his report two critical facts. Quote, hanging is the most common method of self-ending worldwide, and virtually all hangings are self-endings. What? Certainly other forms of neck compression, such as manual and ligature strangulation, occur, but in Massachusetts, the ratio of occurrence between homicidal and self-ending was 21-2. This here has nothing to do with his report. Because now they are, again, here incomplete, and then a few lines further down they go with completed. So they're switching back and forth between a new footnote. Footnote 5. This data was coalesced from 2 Commonwealth state sites. Okay. Petechia hemorrhages. Dr. Baden indicated that these hemorrhages in the eyes and the skin above the ligature, Baden report at 2, are commonly found in homicidal strangulation, manual, and ligature, but not in self-ending hanging. Citing De Mayo and Spitz and Fisher, but upon close review of both of those texts, they do not support this supposition. Okay. De Mayo, in the introduction to the strangulation section, wrote that, quote, there are 3 main forms of strangulation: hanging, ligature strangulation, manual strangulation. Regarding all 3 types of strangulation, De Mayo observed is classically seen in the conjunct. I have no idea what that is. Furthermore, Miss Birchmore's body was found in a position consistent with a seated, incomplete, atypical hanging. What? Yeah, for me that speaks to staging. Meaning that part of her body was touching the ground and the ligature knot was at the side of her neck. Mr. Jingles, what are you doing? Hold on. Mr. Jingles. Oh. Folks, Mr. Jingles caught a mouse, so I need to give him treats for being a good kitten, and then remove the mouse. Go ahead. And I'm back. Hello again. Live or not live mouse? Not live. Not alive. Good thing with living rural is when I need to get rid of dead mouse, I just throw it outside and one of the crows get it. Where were we? Yeah. De Mayo explained that in partial suspension hangings where the carotid arteries and venous drainage are completely occluded, as was likely with Miss Birchmore. What do you mean by that? Was likely with Miss Birchmore? Mr. Defense Attorney, you have the medical examiner's report, which will tell you what happened to Miss Birchmore. So this likely with Miss Birchmore is, so you didn't compare it? What? The vertebral arteries continue to supply blood to the head, producing congestion of the face and this. Thus, facial congestion and petechiae are commonly seen in these cases. Okay? Spitz and Fisher at 406 stated that in case of semi-suspension, arterial blood flow to the head persists while the venous return is interrupted, and noted that over 50% of self-ending hangings show petechial hemorrhages. But in my opinion, hello, Mr. Dimas. In my opinion, this entire section here doesn't matter because they don't draw references with the state's medical examiner's report. And likely means it's contested, which means experts get to try to clarify it to the jury. Battle of the experts. The abrasion of Miss Birchmore. Okay, so that was all they had with that. I'm not even close to convinced. The abrasion on Miss Birchmore's chin. During her examination of Miss Birchmore, the medical examiner noted a, quote, dry yellow abrasion on Miss Birchmore's face. Dr. Baden, without explanation, states that this abrasion occurred or was the result manual and/or ligature strangulation. Baden report F2. Despite his 50 years of experience, it appears Dr. Baden did not consider the obvious alternative that the abrasion was perimortem and consisted with how Miss Birchmore's head was terminally positioned when she was found. Perimortem after death. So they claim the abrasion came. Okay, I haven't seen any of obvious reasons. I haven't seen any pictures of how she was found. I'm not sure there are any. We'll have to wait for trial until find out. Sadly, it's a federal court, which means we don't get to see it, or at least hear about it, except in transcript or from reports from within the courtroom. Okay. But here's the thing. Obvious alternative. Yeah. Meaning there are more than one way, which means you present your expert, the state present there. Does not mean in any way, shape, or form you get to exclude Dr. Baden. It demands that you present your own. The hyoid fracture and the current scientific literature. Dr. Baden's report stated that the hyoid fractures are, quote, commonly found in homicidal strangulation, manual ligature, but not in self-ending hanging. And that according to Dr. Di Maio's textbooks, fracture of the hyoid bone occurs rarely, if at all, in self-ending hanging and does occur in half of homicidal strangulations of women. These conclusory statements ignore a significant and growing body of literature, largely following the latest edition of Di Maio's textbook, proving wrong this long-held assumption. Additionally, these statements, based on only 2 textbooks, fail to acknowledge that even reference textbooks and manuals of forensic pathology do not concur on the occurrence and diagnostic significance of Larry Baba in hanging. I wish I could pronounce those words. I really do. To prevent this court from reading the same recitation of the scientific literature twice, Mr. Farwell incorporates here in section 3AB2 from SMOC 702 motion. The analysis therein directly addresses Dr. Baden's outdated assumption as to frequently of hyoid fractures in self-ending hanging deaths of all kinds. Yeah, but this was not of all kinds, Mr. Defense Attorney. This was from a doorknob where she, more or less, her legs and half her body was on the ground, resting to. Again, I haven't seen any photos of how they found her, but to my understanding, she was more or less, well, half her body was still on the ground. So, of all kinds does not apply here. This specific one applies. Moreover, Dr. Baden does not address the absence of hemorrhage at the blah 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 fracture site, a critical omission. A fracture without hemorrhage means it's likely that the fracture occurred post-mortem. Likely. There's that word again. Likely. Likely. Battle of the experts. Cross-examination. And they reference their own motion, discussing hemorrhage at fracture site, De Mayo 248. Fractures of the blah 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 bone can only be considered antemortem if there is blood at the fracture site. Folks, here is where my 3 years as a documents analyst pays back. See this here? These 3 dots here means they are leaving shit out. So, what are they leaving out? Let's see here. Hold on here. Da, da, da. Let's see here if I can find it easily. Okay, now I know what they are leaving out. Now, Dr. Baden's conclusion is not this fast and strangulation, is asphyxiation with the breakage of this bone. This, at page 248 here, fractures of the hyoid bone can only be considered antemortem if there is blood at the fracture site. In the De Mayo textbook, they are talking about high energy direct trauma, which is not Dr. Baden's conclusion. And that is why they left that part out. How about that? When reviewing that literature, it's also critical to highlight that Dr. Baden's sparse report is devoid of any discussion of the biomechanical factors that impact the likelihood of a hyoid fracture in an incomplete hanging. Now, they're switching back and forth again. Researchers have found that when there is no hemorrhage at the fracture site, as is the case here, those biomechanical factors become a critical component of any analysis as to the cause of the fracture. SMOC 702 motion, section 3B2D. Dr. Baden, okay, let's go next one. Dr. Baden failed to address the absence of certain physical findings typically found in manual and ligature strangulation. The Baden report, page 3, concluded that the autopsy findings are typical for homicidal manual and ligature strangulation and atypical for hanging. Yet Dr. Baden did not mention what was absent from the autopsy findings, indicators of either self-ending or an accidental death. What? The autopsy finding from the state's medical examiner was self-ending. So how could it be absent if the conclusion from the ME was self-ending? Wow. The Mayo states that in most cases of manual strangulation, marks of violence are frequently present on the skin of the neck. That is not Dr. Baden's conclusion. And again, they leave things out with the 3 dots there, meaning they cut shit out. Marks of violence are frequently present on the skin of the neck. That is not what Dr. Baden concluded. He concluded asphyxiation. And where is it? Where is it? Where is it? I had it up here. Yeah, asphyxia strangulation. Which means not violent. Which is quite interesting because according to information that is out, Matthew Farwell, in the text messages between him and Sandra, he liked choking sex. So him slowly asphyxiating her was a kink of his. Yeah. Now where were we? There. And defense wounds on the body of a strangulation victim are frequent. That is still not Dr. Baden's conclusion. There were no defensing wounds because she didn't know she was about to get killed. Despite reviewing autopsy materials indicating and showing no defensive marks, and despite basing his conclusion on aforementioned text, Dr. Baden does not indicate that he weighed or even considered the lack of defensive marks on Miss Birchmore's body. Again, Matthew Farwell's, his kink was choking sex. He choked her while banging her, showing that Dr. Baden's conclusion fits with Farwell's kink. She didn't know. For her, it was just this perv who had groomed her for years since she was a child, just doing his normal pervert stuff. Additionally, other than the left sternothyroid hemorrhage, an injury that often occurs during a self-ending hanging, and the fractured hyoid with no hemorrhage present, the medical examiner did not find any of the other injuries that are typically accompany manual or ligature strangulation. Stated, rarely, no marks are present in manual strangulation. Spitz and Fisher explained that the hallmarks of manual strangulation are fingertip bruises and fingernail marks on the neck. That is still not what Dr. Baden says. Still not. Still not. So this here is now we are getting into gaslighting. How the defense now again, I don't mind them filing this. I know they have to zealously advocate for their client, but now they are getting into trying to gaslight the court. Now we're bordering in on, beyond grasping at straws, in my opinion. As to the suggestion of ligatory strangulation in the Baden report, Dr. Baden provides no explanation other than the generic one outlined ante, nor does he address that there was only furrow marks on Miss Birchmore's neck and no defensive marks, both contradicting of ligature strangulation. Again, you're comparing apples and oranges here. This was a slow asphyxiation strangulation, not the type you're arguing for or against. Dr. Baden erroneously observes that the very tightly applied ligature crossed the mid-neck horizontally. Baden report. He did not grapple with the fact that the medical examiner documented the furrow rises gradually on either side of the neck, and in photographs, an upward cant of the ligature is visible, consistent with self-ending and inconsistent with ligature strangulation. See De Mayo. In ligature strangulation, in contrast to hangings, the ligature mark usually encircles the neck in a horizontal plane, often overlaying the larynx or upper trachea. Spitz and Fisher, in strangulation, the mark on the neck is horizontal. Again, probably taken out of context. And again, I would assume this part is about when it is an absolute violent strangulation, which is not what Dr. Baden says. When reviewing Dr. Baden's physical findings in their totality, it is clear that Dr. Baden did not grapple with or consider research in modern forensic pathology, and that he did not examine any possible alternative explanation for the injuries Miss Birchmore did show. Along with those, she did not. While Dr. Baden is not required as an expert to consider every alternative explanation, he is required to have adequately accounted for obvious alternative explanations. 702 Advisory Committee notes to 2000 Amendment, and this is especially so when those alternatives are present in the very textbook he apparently consulted and cited to justify his opinions. My opinion here is that the defense, grasping at straws, cherry picks. and removes passages from the citations they use, because the passages they use is about violent strangulations. Because Dr. Baden does not demonstrate the reliability of his methodology and the validity of his reasoning, he should not be allowed to testify as to the inferences and conclusion he draws for it. Ruiz-Troche, citing Daubert. Let's see here. What is this? I'm checking here that case. Dun, dun, dun. I see here. Listen to this. When facts are in dispute, experts sometimes reach different conclusions based on competing versions of the facts. The emphasis in the amendment on sufficient facts or data is not intended to authorize a trial court to exclude an expert's testimony on the ground that the court believes one version of the facts and not the other. Defense attorney misrepresented. Interesting. Thus, his testimony as to the physical finding must be excluded under Rule 702. Furthermore, Dr. Baden has 50 years of experience as a forensic pathologist and is a famous television figure, meaning that his testimony may be assigned talismanic significance in the eyes of lay jurors. Fucker. They don't know who he is. And he doesn't have to cite that he is on TV. Now, we in this segment, LawTube, CrimeTube, True Crime, we kind of know of the more famous ones and even less famous ones. A person on the street, if we ask them, hey, do you know what a Daubert hearing is? They would probably say, is that a cartoon? No, no, this is another stretch. And increasing the likelihood the jury will not discern or consider the errors in Dr. Baden's testimony. Therefore, the unreliability of Dr. Baden's testimony creates a high likelihood of unfair prejudice and a propensity to mislead and confuse the jury. Substantially outweighing the probative value of his testimony, Dr. Baden's testimony must also be excluded under Rule 403. I don't see how the state, when they reply to this, because they will go through, okay, what did they actually cite, and what does this case law actually say? Because if I can find it in a minute and a half, the state's the federal prosecutor will also. 2. Dr. Baden's conclusions are based on erroneous and insufficient facts. This is Hail Mary. This is standard. Federal Rules of Evidence 702 requires that an expert's testimony is based on sufficient facts or data. Given that the question of whether a killing occurred in this case, i.e. whether Ms. Birchmore ended herself or was killed is an open one. Yeah, which leads us to a battle of the experts. An expert opining on that question should review all of, or at least most of the available facts around the issue, including facts related to Miss Birchmore's mental health and relevant DNA findings. Oh, really? Are you seriously going into that? Miss Birchmore's mental health. Did Miss Birchmore have mental health issues? Yes. Mainly because she was groomed, raped repeatedly by Matthew Farwell, his twin brother, Mr. Devine, and probably others at that precinct who saw the Stoughton Youth Police Club as a hunting ground. Yeah, that fucks with your mind. But every person who knew Sandra Birchmore at that time knew she was looking forward to becoming a mother. This is a getting close to victim blaming here. Irrelevant DNA findings? What? I'm quite sure that the relevant DNA findings found Matthew Farwell's DNA, panties, and other places, and specifically on the contraption that was put around her neck. Finding that an expert's assertion on a particular matter must have sufficient basis. But I don't. Why would he need? Yeah, okay. Dr. Baden has not reviewed sufficient facts regarding Miss Birchmore's mental health. Here, despite the primary question being whether Miss Birchmore took her own life or was killed, Dr. Baden apparently only had access to the internal affairs report beginning February 5th, 2021. Stoughton Police Department began an internal affairs investigation into the matter of the unattended death of Sandra Birchmore and into the possible violations of the police procedure, rules, and regulations of the Stoughton Police Department. Okay. From which he summarized that Miss Birchmore had told her friends that she was happy that she was pregnant and that Detective Matthew Farwell was the father. However, as described in depth in SMOC 702 motion section 3, Miss Birchmore had an extensive history with mental illness and prone to self-ending. I don't think so. Hold on here. There are no attempt of self-ending on the record regarding Sandra. None. Zero. That Dr. Biden was not provided those materials or any of Miss Birchmore's mental health records means his testimony as to her mental state and the cause of manner of her death should be excluded. Fuck you! Fuck you to hell. Now you passed the line. This is no longer zealously advocating for your client. This is making shit up. Steve asks, is there any evidence she was in care for self-ending? There are no medical or mental health records on Sandra Birchmore of her ever attempting self-ending. Dr. Baden has not reviewed the DNA results in this case. On page 3 of this report, Dr. Baden states, it appears that the SA kit was not tested at all. This is incorrect. An April 22nd, 2021 report by the MSP Crime Lab noted that a general examination of items from was performed. In addition, a general examination was conducted of sample for Miss Birchmore's underpants, yada yada yada. Subsequently, reports noted additional testing of swabs and stains from Miss Birchmore's underpants, as well as testing samples from the ligature found around Miss Birchmore's neck and fingernail clipping from both of Miss Birchmore's hands. Yeah, DNA. It appears that this SA kit was not tested at all. In what context? I think they're leaving out context here. Because general examination is not testing. Screening, testing samples. MSPCL reports note additional testing of swabs and stains. I sense there is something missing here. I don't think Dr. Baden would miss all of this. I don't know. Critically, the fact that Dr. Baden was unaware that DNA was tested in 2021 means that he formed his opinion with insufficient facts, including that the DNA collected from underneath Miss Birchmore's fingernails totally excluded Mr. Farwell as the source of the male DNA that was recovered from underneath Miss Birchmore's fingernails. There were no defensive wounds. She never got to try to claw because she didn't know that Matthew Farwell allegedly just continued. She passed out, not knowing she was about to die. Hence, no defensive wounds, hence no clawing, hence no DNA under the fingernails. But there are Matthew Farwell's DNA on her and in her and on the alleged murder weapon. The absence of Mr. Farwell's DNA from Miss Birchmore's fingernail clippings bears directly on physical contact with her on the night of her suspected death and whether her death was caused by a struggle. They are not claiming struggle. That's a straw man argument. Footnote 11. Oh, it's just a case. Additionally, the majority of DNA testing on the ligature and Miss Birchmore's underwear involved complex mixtures involving 3 or more contributors, and thus cannot be said to match any single individual. Today's DNA testing can separate. If it's just 3, they separate it. They test and then they match. And Mr. Farwell is a match. This is a clear misrepresentation of the current and for the past 5 to 10 years of DNA testing from the defense. Throughout the DNA testing process, the MSPCL neglected to include samples from William Farwell, Mr. Farwell's fraternal twin, which casts doubt on any testing that provides statistical support for the inclusion of Matthew Farwell's DNA. You know what? Do you know why they didn't test Bill Farwell? He wasn't there. He did not go into Sandra Birchmore's apartment. He did not exit Sandra Birchmore's apartment. If Bill has a solid alibi, why would they need to test him? Unless the defense are going to blame Bill Farwell for the murder. See also defendant's motion in limine to exclude from argument or testimony describing improper conclusions from complex DNA mixture evidence. Yeah, that will be denied. If it's not already denied, it will be. With regard to the fetal tissue recovered from Ms. Birchmore, Bode Technology detailed testing performed in the January 20th, 2025 report, and then issued a supplemental report regarding testing of the samples in April 2025. The government provided additional DNA testings from Bode Technology, which exclude Matthew Farwell as the biological father. It doesn't matter. What matters is what he thought. And when Sandra said, "I'm pregnant, you're the dad," he thought he was the dad. It doesn't matter who was the actual dad. Having demonstrated that Dr. Baden formed his opinion with erroneous facts, that the essay kit was not tested, and insufficient facts, this is circular argument. They are referencing their own prior and current motion in limine to get this motion in limine. That's not how it works. This motion in limine must work by itself. If the others are denied, this should survive on its own merit. I assume this seems to be how the defense works here. They reference other motion in limine, which is dangerous because the court says, yeah, we deny those, we will deny this one. Always write a motion in limine so it survives on its own. His opinion is unreliable. Further, according to the expert witness disclosure served on the defense by the prosecution, Dr. Baden still has not reviewed those results. Because the DNA result does not matter, and her finger clippings does not matter because his conclusion is that it was not that type of strangulation. Because, quote, a certain patina attaches to an expert's testimony, unlike any other witness. This is science, a professional judgment. The jury may think and give more credence to the testimony than it may deserve. Do you know what the cure for that is? Bring your own expert. Bring your own expert. Cross-examination cures that. And they quote, blah, blah, blah. Dr. Baden's opinions bear that patina of expertise, even though they are not based on sufficient or accurate information. Again, circular argument. And even though they omit, and indeed seem to not consider at all, the complicated reality of Ms. Birchmore's mental health or the DNA findings excluding Mr. Farwell, thus the opinions are highly likely to mislead the jury on the central issue in this case, whether a killing occurred. Yep. You yourself are omitting the other DNA results and trying to get those DNA results excluded because it's a mix. It doesn't work that way. Consequently, his testimony is excludable under Rule 702. Additionally, because of the risk of substantial prejudice that will arise for Dr. Baden's unreliable opinions outweighs any probative value of those opinions, his opinions must also be excluded under Rule 403. I do not agree. Okay. And this, I believe, will be the court's decision. Bring your own expert. Cross-examine. Ta-da! Dr. Baden's opinion contained analytical gaps. Dr. Baden's unsupported speculation as to Miss Birchmore's hair entangled in the ligature. Citing only his experience, which he can, he is an expert in the field, Dr. Baden makes the following assumption in his report, that women are, quote, careful to place the ligature against the skin underneath the hair. Dr. Baden has done this for 50 years. That women do not let ligature get entangled within their hair. The tangled hair only occurs when there is resistance during homicidal strangulation, and that the aforementioned is apparent in Miss Birchmore's autopsy photographs. Dr. Baden provides no explanation, no data or statistics or any other basis for any of these assumptions. Great! That would be excellent for a cross-examination. As this court has previously explained, quote, any expert may, ... testify solely on the basis of experience, but he must explain how that experience leads to the conclusion reached, why the experience is sufficient basis for the opinion, and that experience is reliable applied to the facts. Yeah, this is his experience. Women do not let ligature get entangled. Here is his explanation. It's just that you quoted the explanation right here. It's just that you don't like the explanation, and that is not a legal argument. We don't like it. When the expert fails to do this, the expert and his proponent ask the court to simply take this expert's word for it, but quote, nothing in either Daubert or the federal rules of evidence requires a district court to admit opinion evidence that is connected to existing data only by the ipse dixit of the expert. So it is on the discretion of the court. Dr. Baden's subjective belief or unsupported speculation that Miss Birchmore's death was a staged homicide. Footnote 12. Joyner quoting Daubert. Okay. Dr. Baden, without providing any rationale or evidence, pronounced that, quote, the neck ligature was tied to doorknob to give the appearance of a self-ending hanging. This absolutist and unsupported speculation must be excluded because Dr. Baden has not shown a, quote, reliable basis to reach his opinion. Again, circular argument. They don't think he has a reliable basis, even though they quote him all the time. How and why he reached his conclusions. No. See Khaleesi, blah, 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 at 13. And it contains a yawning, quote, analytical gap between the available facts and the opinion proffered. A yawning gap? Now you're just being an asshole. First, Dr. Baden has not only failed to show a reliable basis to reach his opinion, I believe he has provided no basis at all for this opinion. He has. It's a 4-page. 4 pages. And you directly quote him from that where he gives his explanations. It's simply a statement in his report with nothing more. Second, Dr. Baden reviewed autopsy and toxicology reports and scene and autopsy photographs, though Marullo and Smith likely had the first responder reports detailing the scene. It does not appear that Dr. Baden received and or reviewed them. Who knew that Marullo and Smith, after knowing that the first responders fucked up royally, that those were not reliable? Remember, folks, when Sandra's family came to the scene, they found her necklace with a pendant ripped off under the bed. That is how good their investigation was. They didn't even look under the bed. Seriously. So, yeah. Why didn't they want to give that to Dr. Baden? Well, also, those cops are not medical examiners. Their opinions really doesn't matter. Folks, imagine this. And I'm borrowing this from Brother Counsel. Imagine you're driving your car. You're driving your car through an intersection. The light is green, you drive through. Later, somebody at that very intersection was stabbed. Now, according to cops, well, you were there at the scene. That makes you a suspect. Even though everything there shows, yeah, but just drove through. Yeah, but you were there. That's enough. No, you have to investigate further to reach a conclusion. This is what happened here. They went in there, they saw Sandra, and just made a conclusion. Left tons of evidence in the apartment. Ignored evidence in the apartment to reach that conclusion that it was self-ending. Even though Dr. Baden's investigation, the family's investigation, the DNA results, the text messages, everything points to Matthew Farwell. That is why there's no need for Dr. Baden to be, hey, look at this opinion from the people who were there and fucked things up to begin with. To make such a conclusive determination that the scene was staged, it would seem critical that the expert had either visited the scene while the body was still present. Never going to happen. What? A defense expert or a state expert going to the scene? Fucker, not even the state medical examiner was at the scene for the initial findings. This is now you're going into stupid. Or review the observation noted by those who were not reliable and not scientific. Had he reviewed those reports, Dr. Baden would have seen that the first responder found no sign of struggle in Miss Birchmore's apartment, no drag marks, and did not note any indications of an attempt to cover marks or tracks. Yeah, they also, as I just said, didn't look under the bed for Sandra's necklace and pendant that was ripped off, broken. Huh? Jesus. And Matthew Farwell is a big dude. Let's see here. Let's see if I can find it. Let's just say Sandra Birchmore. Let's see. Matthew Farwell, a trained police officer, was 6'4", my height, and I'm a big guy, and way over 200 pounds. Well over 200 pounds. So thinner than me, but as tall as I am. And I'm a big dude. And I'm not a trained police officer. Now let's see. Sandra Birchmore, 4'10". And maybe 120. 4'10" against a 6'4" police officer who is trained on crime scenes, who knows how to do it. Yeah. Of course, it's not going to leave obvious things. I mean, it's not like he might have, we don't know, videotaped himself doing it, because we know he liked to, how do you say this? Document his encounters with Sandra. So, yeah, I wonder why there weren't more obvious signs. Given Dr. Bailey's failure to provide any evidence or basis for making this conclusion in this case, no, he does. It's just that you don't agree with it. As well as any explanation of the principle and method he applied to make such a conclusion. He did. You just don't like what he said. There's no way for anyone to critically review or test the principle and methods Dr. Baden is applying to declare a staged homicide. What is... Fucker! What's this then? This is you disseminating his findings. This is excellent for cross-examination. You'll make a fool out of yourself, but it's still your option to cross-examine, and you show you can by this filing. Notably, one study included a literature review reference Mock 702 motion at section 3b, cautions against the very type of definitive conclusion that Dr. Baden draws. Okay, what was that literature review referenced in their own motion? Okay, but what is it? Okay. Chapters on the asphyxia in different edition of the textbook, e.g. Spitz and Diaz, consistently state that in hanging cases, fractures of the yoyoid or thyroid cartilage are the exception rather than the rule. Yeah, again, we went through this. It is you comparing apples with oranges. You compare it with a successful standalone hanging with Sandra Birchmore's staged, where half her body was on the ground, on the doorknob. That is a very specific case that has to be analyzed as that, not against everything else, as that, which is what Dr. Baden did. When viewing Dr. Baden's conclusion that Miss Birchmore's death was a staged homicide, staged self-ending, In totality, it is no, quote, more than unsupported speculation or abstract beliefs. Just because you don't agree with it doesn't make it untrue. Dr. Baden, quote, does not document any methodology he used to reach his conclusion. He did. You have referenced his you just referenced it. Throughout this filing, you have referenced it. Seems to be suggesting that the court can rely solely upon his training and experience. Actually, they can. Because this conclusion is simply ipse dixit and is completely unfounded. The proposed opinion does not satisfy 702, and it must be excluded. I can't wait for the Fed's reply to this. I hope it will show up soon, because this is horse shit, folks. This is horse shit. The same deficiencies should exclude his testimony under 403 as well. Dr. Baden's expert status puts the patina of science on a speculative conclusion contravened by evidence, misleading a layperson jury to make inferences that are unfairly prejudicial to Mr. Farwell regarding a critical issue in this case. The very real risk of unfair prejudice tips the scales, substantially outweighing any probative value this testimony might hold, and given its lack of foundation, that value is minimal at best. I do not agree in the slightest. Not in the slightest. Through your filing alone, you have referenced how Dr. Baden got to his conclusion. In your own references, you yourself have shown how he got there. So I doubt this will be successful. Dr. Baden's unsupported determination as to the cause and manner of Miss Birchmore's death. While Dr. Baden may be a forensic pathologist and has had the authority and training to determine cause of manner of death, in this case, as outlined ante, there are significant deficiencies in the facts and research he was provided or considered, the analysis he undertook, and the analytical gaps present in his analysis do not provide a sufficient basis for his determination that, quote, the cause of Miss Birchmore's death is strangulation and the manner of death is homicide. Well, you quoted him, and I bet those 4 pages contains a lot more than what you quoted in your filing. A lot more. Incorporating all the arguments herein, Dr. Baden's ultimate opinion does not rest upon good grounds based on what is known. What is known. The court's role in a Daubert challenge is to make certain that an expert, whether basing testimony on professional studies or personal experience, employs in the courtroom the same level of intellectual rigor that characterizes the practice of an expert in the relevant field. With this report, Dr. Baden employed the required level of intellectual rigor, as his report demonstrates that too great an analytical gap exists between the existing data and Dr. Baden's conclusion. I would argue that the misrepresentations from the defense here regarding what the case law actually says and what is actually said in the textbooks will be apparent once the Feds files their reply to this. Now, again, I don't mind them filing this, because if they do their absolute best, even threads the lines of decency to defend Mr. Farwell, the conviction will be more solid. The conviction will be undeniable. Folks, this is not the Delphi case, where Judge Gull denied the defense, third-party culprit defense, where Judge Gull denied the leading expert in ritual killings. There is no other Dr. Perlmutter is the leading expert in that field. She literally writes the book on ritual killings, and she was denied to testify. This is not Judge Gull. This is not Judge Bev. This is the federal court. This type of shenanigans I expect from the state in Massachusetts, in Norfolk County. I expect this kind of shenanigans from the DA in the Delphi case. I expect a little more decency from the defense. And additionally, because the evidence brings unfair prejudice and a cognizable risk of confusing the jury, and the risk substantially overbalances any probative value, then the evidence must be excluded. Consequently, for all the reasons discussed ante, this court should exclude Dr. Balin's testimony as to the cause and manner of death under both Rules 702 and 403. And they request a hearing, the Daubert hearing. I would love for a Daubert hearing on this. I actually would. Is there a chance that the court says, oh, hell no, but we still need to wait for the feds to reply to this? And I hope it comes soon so they can dismantle the bullshittery from the defense in this case. Again, I don't mind filings like this because it will, as I said, it will only solidify the conviction. It will be bulletproof against appeal. Because if the defense fights hard and dirty like this, they are doing their absolute best. Which means Farwell can never argue insufficient representation from counsel. That's gone. He will just be, hopefully, a very guilty groomer, rapist, and murderer serving the rest of his life behind bars in a federal prison as a murderer not only of Sandra Birchmore, but as a murderer of her unborn child. I don't think there's more here. No. Folks, again, now we have to wait for the reply to this. It will be a reply. And when it shows up on the docket, I'm going to go through it with you guys. All of it. Folks, thank you. Thank you for allowing me to do this. Thank you for your interest in this case. It is absolutely horrific. Not only because of the facts, but it is the same Norfolk County that tried to frame Karen Reed. That's the same county who protects the House defendants, that tried to protect a lot of police officers, and they do it in both the Karen Reed case and in the Sandra Birchmore case. So, more on this as filings comes through. Now, folks, tomorrow, Slightly Buzzed show, 5 p.m. Eastern Time, and it will be a Canton special, because there's been a lot of filings. And even, I believe it was a hearing that is now, let's see here. Dun, dun, dun. One of the latest hearings the video has come out, so we are going to watch that. I'm going to invite a bunch of new guests. Well, I will of course invite the usual ones, but I'm trying to invite Boozy Beauty. So, folks, I'm going to keep contacting her because or talk to her to get her to my show. You can help by going over to Boozy Beauty's next live stream and say, you have to be on Nick's Slightly Buzzed show. That is how you can help. And I hope you do. Folks, again, thank you. From me and Mr. Jingles, who is now outside catching new mice. Good. Which is great. Just as long as it doesn't bring live ones in here. Because I don't want to chase them. All right. Folks, again, thank you. And let's see. Can I redirect you to anyone? Let's see here. Dun, dun, dun. Hey, Rob is streaming. Hey, Rob is streaming about the Laura Owens case. So I'm going to send you over to him. All right, folks. That is what I had for you. Thank you again. And I will see you all in the next stream or video. Bye-bye.
Santa Claus, riding in with the winter laws. Santa